Shalom, my name is Michael Decker, and I'm a lawyer within the law offices of Cohen Decker, Pex and Brosh. Our office handles estate matters and inheritance matters regarding wills and inheritance by law. And today I wanted basically to discuss with you regarding a certain important Supreme Court decision that was rendered in Israel by Justice Aharon Barak. The name of this court decision is Talmachyo Against the custodian, the general custodian, and the number of the court decision is 1900 on 96. Basically, this court decision dealt with a deceased who left her estate to a certain person, and the rest of her estate, which was specifically in a certain specific bank account in Bank Leumi on Arlozorov Street in Tel Aviv, she decided to use all the monies in that account and all the savings in that account in order to establish a trust that would go to orphans of IDF soldiers, and that the rest of her property that is not in the specific bank account would go to another heir. After the deceased wrote this will, she basically transferred all the funds she had in a Lozorov bank account to a different bank account, to a bank account in Kikar HaMedina, which also belonged to the Leumi Bank. The appellant and the plaintiff in this court decision is the other heir, and she argued that because the deceased transferred all the funds from a Arlozorov account to an account in Kikar HaMedina, and because the deceased specifically mentioned in the will that only the monies and the savings that are in the Arlozorov account will be used to establish a trust, that the simple interpretation and the technical interpretation of the will determines that she is the full heir of everything, because everything else is not in the Arlozorov bank account. She inherited. The district court did not accept this position of the plaintiff, and then the plaintiff submitted an appeal before the Supreme Court, and this case reached Aharon Barak. Aharon Barak agreed with the district court. The district court basically ruled that all the monies that were transferred to the Kikar Leumi account, to Kikar Medina account of Bank Leumi, would also be used in order to establish a trust, and that this was basically the desire of the deceased. But Aharon Barak said that this conclusion cannot be reached without providing an essential interpretation to the will. And Aharon Barak, who liked to provide essential interpretations to various matters, basically determined that there are 4 tests which can be used in order to find an essential interpretation to a will, even though the technical wording of the will states maybe even the opposite. The 4 tests that were determined are as follows. The first is an amendment to the technical wording of the will. For example, if there is a deceased that has a winery in his basement, and in the basement there's also bookshelves, and these wines are worth millions of dollars, for example, and in the eyes of the deceased, he called this winery a bookshelf, and he always used to call this winery a bookshelf, and in his subjective reality, the winery is a bookshelf, but objectively speaking, a bookshelf is a bookshelf, and a winery is a winery. But if the heir can prove through external circumstances that the deceased, his whole life, referred to this bookshelf as a winery, he can argue that the idea behind the word bookshelf is that he inherits the winery. that's in the basement, and not just the books. So that's the first test, to amend the simple wording of the will. The second test is to fulfill lacking in the will, something that doesn't exist. For example, if a deceased had 2 kids and he gave all his inheritance to these 2 kids and he specified them by name, but then afterwards he had another child and he forgot to amend the will and to add the other child to the will, and if this third child can prove that the real intention of the deceased was to grant to all his children equally the estate, he could argue that this will needs to be fulfilled and that he should also be added to the will, even though the will does not even include him. And that's the second test, to add and to fulfill a lacking in a will. The third test is to fulfill as close as possible the desire of the deceased. For example, if the deceased wanted to bequeath his estate to a certain orphanage, and then prior to his passing away or after his passing away, this orphanage doesn't exist anymore. It shuts down. Then the judge could decide that this estate will need to be given to a different orphanage, because that would be an alternative fulfillment in the closest way possible to the desire of the deceased. The fourth test is a change, to exchange basically the estate or the specific property to a different property. For example, if someone bequeaths a certain property, a certain apartment, to an heir, and describes this apartment as an apartment in a certain city and in a certain street, and this was a case that actually existed, and then after the deceased wrote the will, he sold this specific apartment and bought another apartment with the money which was used from that sale, then the heir can argue that even though the will specifically mentions a very specific apartment that he's supposed to inherit, he is now the heir of the new apartment that was purchased by the deceased with the monies which he received from the sale of the previous apartment. As mentioned in the case of Talmachyo versus the custodian, the Supreme Court basically determined that all the monies that were in Arlozorov that were supposed to be used to establish a trust but were now transferred to Kikar Medina branch in Tel Aviv in Bank Leumi, the same monies that were transferred should also be used to establish a trust for the purpose of orphans of IDF soldiers. I hope you enjoyed this short explanation. If you have a situation that's similar in a will that needs to be implemented, maybe in a different way, we'll be happy to hear you out, and you can feel free to contact us. Thank you very much for your time.